Hi, I'm going to take about 15 minutes to tell you some of the reasons that I believe that we've started to turn the tide on keeping our public lands open to the public. And in this, I'm going to talk about some of the legal battles that we've had some really good successes with in the past year or so. The first is a Supreme Court decision that was made in 2022, and it introduced the major questions doctrine. This is a very important restriction on the power of the federal government, and it actually stated that courts can't defer to agencies as the experts on matters of vast economic or political significance. So on really big items, they can't defer to the agencies and say the agency knows best. This is an important change that has restricted the federal government's power in administrative agencies that are unelected. The second case that I want to talk about is Loper Bright versus Raimondo. This is a landmark decision. It was issued in June of 2024. The attorney of record was Paul Clement that represented the case. And basically it abolished the Chevron doctrine that stood since 1984. It's been used in thousands of cases, and basically the Chevron doctrine stated very clearly that courts had to defer to the federal agencies as the experts in matters of all matters. Chief Justice Roberts ruled that courts must exercise their independent judgment in deciding whether an agency has acted within their statutory authority. This significantly reduces the power of the federal agencies to be able to make rules and be able to expand on matters that are not specifically designated to them by Congress. The third case is Corner Post versus the Federal Reserve. Now you might ask, what do credit card interchange fees have to do with keeping our public lands open? Well, it's very important because a lot of times the devil is always in the details. And what this case determined is that the statute of limitations, which is often a bar to many of our cases, begins to accrue when a plaintiff has both experienced an injury and the agency action causing that action has become final. Many times these laws are passed years before, and the court cases are barred because the statute of limitations has expired. This no longer brings that into vogue because now the statute of limitations begins when the negative impact begins. So this is a very important decision. It's already been cited in a number of land use decisions. The next one is Seven Counties versus Eagle County. This is one in Utah, and it involves a rail line that was approved by a NEPA study for construction to get crude oil to the main rail line. And NEPA approved it, and the challenge by Eagle County, Colorado was raised that the NEPA study was inadequate because it did not consider the downwind impacts of the decision adequately. For example, they concerned about the pollution factors that would go on from Colorado as a result of the mining, the oil wells, and the transportation and building the rail line. They even went as far as to say that they did not analyze the effects of the oil refining that was done on the Gulf Coast as part of the environmental impact. So this is going to be a very, very important one, and it's going to be heard sometime in this next court session. So sometime by the end of June of 2025, we'll hear a decision on this one. You've probably heard about Utah versus the United States. This is the case that the state of Utah filed against the United States in the Supreme Court direct, and it challenges BLM's perpetual ownership of land on unallocated land. The enumerated powers of the Constitution really define what authorities the United States has as a federal government, and then all the other powers are enumerated back to the states. And this is an original jurisdiction case, which means it did not have to go through the district court, the appeal court. It could go directly to the Supreme Court. Probably the most significant benefit of this case, or the strongest proponent of this case, is the attorney that's representing it. Paul Clement is the winningest Supreme Court attorney. He's taken more cases to the Supreme Court. He's won more cases in the Supreme Court than any other attorney. So I am very, very enthusiastic that Paul Clement agreed to take this case. He doesn't take losers. If he didn't think there was a strong chance that he could win in the Supreme Court, he wouldn't have taken the case. This would remove the ability for BLM to continue to own land that's not allocated. Allocated lands are things like national parks. Wilderness study areas are allocated. Military bases are allocated. Government buildings are allocated. Those are uses that are allowed under the enumerated powers clause of the Constitution. Any other power is relegated back to the state. One that we've had a big win by Blue Ribbon Coalition is Blue Ribbon versus Merrick Garland. And did you know that you're required to have a commercial filming permit if you film on public lands such as National Park Service and then post those on a platform like YouTube where that video could be monetized? Doesn't have to be monetized. The fact that it could be monetized was the subject or the reason that the National Park Service ruled that you had to have a commercial filming permit. Judge Nye granted an injunction that allows Blue Ribbon Coalition members to film without a commercial filming permit on public lands. So this is a big win. If you're a Blue Ribbon Coalition member, you can go out and film and record your videos onto YouTube, social media of any type, without any repercussions for not having a permit. So this is a big win. Another big win by Blue Ribbon is Garfield County versus Biden and Dalton versus Biden. And it represents the 10th Circuit, which is Wyoming, Utah, Colorado, New Mexico, Kansas, and Oklahoma. And it was regarding the scope of the national monument designations. The key question here is, does the federal government have any, or does the president have any limitations on his ability to declare national monuments? Are there any limitations? And Jones Day, which is a national law firm, very prestigious law firm based in Washington, D.C., they really challenged the powers of the United States federal government. And Jones Day took this case, and just one of the three justices that was hearing the case was pounding BLM's attorney for an answer to a very simple question. If the president decided that the state of Utah could be designated as a national monument, would there be any restriction on the ability of the president to declare the entire state a national monument? The judge asked that question of the attorney 3 times, and the attorney did not answer on any of the 3 occasions. This was a very clear decision supported by the other 2 justices on the panel that we are looking forward to getting a positive outcome on this case. And this could completely change the landscape of what's going on with national monuments. Everybody's heard about the Moab case, where they closed 317 miles of trails. This case was delayed for a couple months because of all these Supreme Court decisions, and likely now because of the Kane County decision, which I'll talk about next. The briefs were just filed by Blue Ribbon Coalition just last week, and federal government has 30 days to be able to prepare their briefs and respond back to them. So we'll look forward to hearing this case gain some traction after the first of the year. Kane County versus the United States is a case that's been in the court system for many, many years. Judge Clark Wattops is the judge that's hearing this case, and it really involves the legitimacy of RS 2477 roads. There's about 12,000 claims of RS 2477 roads in the state of Utah. And the way that BLM has been ruling on these is that the state has to take each one of these roads individually and bring them to suit to have them adjudicated. In other words, for a court to be able to rule on whether it's a legitimate claim or not. This case turned that upside down. Now, Judge Wattops has ruled that BLM has to recognize those 12,000 claims as RS 2477 legitimate right-of-way claims. And if the BLM wants to challenge those claims, they must challenge them one at a time. This is an 80-page decision that I really encourage you to read because it has many other insights as to what Judge Wattops is thinking on the outcome of keeping public lands open for the public, for all users. So I encourage you to go to our website and to read the 80-page decision. It's been highlighted to show you some of the major parts, and I think it's probably one of the most important decisions that we've seen in many years. So now what? These cases offer new arguments for litigation. So they give us both new arguments to make as we go forward with land use decisions, and also arguments for litigation that's already been started, even perhaps litigation that was dismissed because of the Chevron deference or the statute of limitations being ruled out. So what do we need to do? We haven't won, but we are showing some signs of winning. We got to keep up what we're doing on every front. We've got to work legislative, we got to work judicial, and we also have to work the administrative. So we got to keep going. There's still challenges ahead. The Kanab area is our immediate challenge that's coming up very soon. There's going to be Trail Canyon, which will be released in the month of November, and it involves some very important trails like the Barracks Trail, Poverty Wash, Lamb Point, and the Pictograph Trail. Then the Paunsaugunt TMAs will be released in April. So these are very, very important to fight hard, and we really need your help. Comments are critically important on individual trails. UPLA, Blue Ribbon, the state of Utah, we're very good and very capable of making the legal arguments on why these travel management plans are inappropriate. But we can't survey all the trails. We really need your input on individual trails, on what we need to do to keep those trails open and why they're important. Federal agencies are required to respond to every substantive comment that is submitted, and if they fail to respond or inadequately respond, that's a very effective basis for legal challenges. It's also important for you to know that Blue Ribbon can represent you when you are a member that submits comments. So anytime you submit a comment, you need to specify the groups that you're a part of. Specify that you're a member of Blue Ribbon. Specify that you're a member of Utah Public Lands Alliance, whatever your local club is. Make sure that you comment and include those in your comments. We've always had a challenge with a 30-day period. Sometimes it's 45 days when comments are announced open on BLM actions or Forest Service. It's just not enough time for us to mobilize people, get people to submit substantive comments, go back through your pictures that you took 2 years ago on a trail that you barely remember the details of. So we have adopted a database program called trailsaver.com, and trailsaver.com will collect your comments. So when you get done with a trail, anytime, anywhere in the state of Utah, write a short report on that trail. Just a couple paragraphs is probably more than enough. Include some pictures that you took on the trail. The important thing is show why keeping this trail open is important. That's the thing that Blue Ribbon, UPLA, we can't do that in our comments. We don't have the manpower to be able to go out and survey every trail in the state of Utah. So please look up trailsaver.com. We have stickers available to promote the program, so you can put stickers on your rigs and then invite other people that you run into on a trail. When they see the red sticker, they'll ask you what it is and you explain to them what it is. If you go out on a club run and you have 10 rigs on your club run, invite everyone to submit comments. Everybody sees something different, and everybody has the ability to find that nest egg that will keep a trail open. So what else can you do? Last closing comment is join or donate to both Blue Ribbon Coalition and Utah Public Lands Alliance. We're fighting for you, but we're a 501c3 and we depend on user donations to be able to survive and to fight the battles. Please get involved, keep doing what you're doing, and get out there, run trails, and keep them open.
Together, we will win. But we can't do it without you. Learn how you can help at utahpla.com/help.